I think there's a couple of issues with, at least in my industry and in my working with settlement. The very first decision that I have to make is, am I even going to bother my trial counsel with the whole settlement discussion? We have some huge cases worth a lot of money for our company. And I want, in many cases, my trial counsel to worry about trial. And then I will work with a different counsel and we'll try to worry about settlement. So, you know, if you get out there, and this happened, Fran Morrison was talking about a trial that he did. There are times that I'm talking settlement and my trial counsel have no idea that I am. And that's not a bad thing. That's really a good thing because I don't want to take a litigator. You know, you focus on winning this trial if we go there. Here's my number one bitch about outside counsel. It's called being accountable. And you talked a little bit, and it was a great point about I am accountable as an in-house counsel. And you know what makes me accountable? Dollars and cents. That's what makes me accountable. So, comes time for settlement. Trial counsel is really a very important part of settlement because you have to tell me what's my case like. Okay? And now, based on the case, I can say, how much money am I willing to settle for? Should I, you know, that's very important, and it's dollars and cents. What you guys don't like to do as trial counsel, and I find this funny because I never did it being in private practice, I'm going to ask you now for percentages. What's the likelihood that we're going to win? And there are people in this room that don't like hearing that. But guess what? That's the wave of the future. What's the likelihood? Because I go back to my business community and I say, here's the numbers. And they want numbers. And they feel it's my job to get them the numbers. And then it's a pretty easy decision from that point. So in the future, well, at least in my industry, at least if you ever work for me, I will be asking you for dollars and cents and chances of success in percentages. And more likely than not, doesn't make it anymore in our industry. The other thing that I find interesting about settlement, personally, when does inside counsel do settlement? When do we give it to outside counsel? When I give a settlement to outside counsel, I want you guys to be in control. And that's kind of difficult. I mean, I don't want the, you know, let's talk for half an hour. Well, gee, I can't say yes or no to that. You know, I've got to go back to my client. That's another part of the decision. When do I do settlement discussions? You know, I know you guys will find this hard to believe, but we don't tell you everything. So, you know, depending upon what I'm not telling you, I may want to do that settlement, okay? Because if I give it to an outside law firm, I want you guys to be in control. And I want the other side to look at you as if you're in control. So those are some kind of thoughts now.
I echo a lot of what Jim said. A lot of times if I see a case getting away from trial counsel or I don't like where it's heading, because we deal with certainty all the time too, as Jim's saying, I have to report to senior management as to what do we expect the case to come in at. A lot of times I'll get separate settlement counsel to come in and deal with the overwhelming, you know, end result of the case to settle it. I had a situation in Alabama where I didn't like how close the defense counsel and plaintiff's counsel were getting. So I brought in, you know, an SOB from Philadelphia to go down there that none of the people liked down there, the judge or anybody else or the mediator. And we held firm with our number. We weren't going to let the case get away from us with the $75 million number that the defense counsel was telling us we should settle at, and we had a much lower evaluation. So I agree with Jim. It's valuable to separate the trial counsel and settlement counsel a lot of times.
Yeah, totally agree with that too. And it's always, for us in Bermuda, a bit of a problem because we don't have as easy opportunity to have direct contact with what's going on in underlying litigation. But when we do have that opportunity, we're always thinking about settlement counsel outside of what's going on with the litigation. You always want a strong defense going on, but one of the first things we think about if we get the opportunity is bringing in settlement counsel of our choice. And it works out great. I mean, you know, if it turns out that it's going to be defended to the bitter end, you're always ready. But at the same time, you're not going to miss an opportunity. You have somebody local who knows when to come in. You've been assessing the case and not disturbing the defense of the case, and it just increases your options.
I'll echo what my fellow members of the panel was saying. I think it really depends on the situation. The one point I would make in the interest of time is who has the best relationship and what your comfort level is. If we do a deal with a particular company, Jim and I actually settled a case between us where we had a dispute, and I happen to know Jim a little, so we spent a lot of time together. Other times, I don't really know anybody in-house, and the outside counsel has the relationship. So I think you really want to give some serious thought to where the relationships are, and some of the other dynamics that were mentioned obviously are important as well.